Hello, everyone. My name is Stephen Gann, and I'm your moderator for today's webinar, Russia's Credit and Collection Environment, Challenges and Opportunities. We have quite a large crowd in attendance today from around the globe, and I thank you all for being here. Today's webinar, the first of many under the Bierens Education Series, is sponsored by Bierens European Collection Attorneys. Bierens, established in 1952, is the oldest and largest commercial collection law firm in Europe. With a team of over 100 attorneys and staff, Bierens provides a one-stop shop model for your complete business-to-business debt recovery process throughout all of Europe. Before starting our webinar, let me take a moment to bring your attention to one item on the control panel on your screen. When you logged in and connected, a little control panel should have popped up on the right side of your computer screen. Towards the bottom of the control panel is where you can send in a question. As we'll be having the Q&A session after the presentation, please feel free to send in your questions along the way, and as best as possible, we'll try to get to all of them. Regarding today's presentation materials, please contact us afterwards, and we'll be happy to email them out to you. Now, let me take a moment to briefly introduce today's presenter, Ms. Yekaterina Titova. Ms. Titova obtained her bachelor's in law from the National Research University Higher School of Economics in St. Petersburg, writing her thesis on private international law. She also received her master's degree in international business law from the Vrije University of Amsterdam. During her studies, she has completed a number of legal internships working for both governmental and private organizations dealing with bankruptcy, insurance, and private international legal matters. Since joining the Bierens International team of lawyers, Ms. Titova has been successfully representing clients for collections, litigation, and consulting throughout Russia. So with that, let's get started. Ms. Titova, please take it away.
Hi, Steve. Thanks so much for your kind introduction. And good afternoon, everyone. My name is Yekaterina Titova, and I'm an attorney with Bierens Debt Recovery Lawyers. And as Steven stated, I'm in charge of our clients' commercial and legal matters in Russia and in some Commonwealth of Independent State countries. It is a great pleasure for me to have the opportunity to speak with all of you today, and of course I will try to make it as informative and practical as possible. And let me start by briefly reviewing the items that I'll talk about during my presentation. I have divided my presentation into two parts, and each of these parts will give you a better understanding of Russian credit and collection environment. During the first part, I'm going to give Russia's country overview. More specifically, we will briefly consider basic facts about the country that are important to be aware of. I will also mention some relevant political and economic updates from the last year and give an account of the current country's risk assessment. As for the second part, during the second part of my presentation, I'll give you a detailed account of legal highlights that you should keep in mind while doing business with Russian counterparts. More specifically, I will talk about the Russian legal environment and judicial system, interest and collection costs, legal proceedings, and the costs to go to court. I will also mention what do you need to know about the bankruptcy and enforcement proceedings, which includes enforcement of foreign judgments and also judgments from different European Union countries. And in the end section of this presentation, I will also share some public resources of information that might be very helpful for you. Let's start the presentation with a brief country profile. Having its capital in Moscow, Russia's population is surprisingly much smaller than the US population, and it amounts to 144.5 million people. As for the gross domestic product in Russia, it was about 1.3 trillion American dollars in 2015, and it represents 2.15% of the world's economy. And according to Russian Economic Development Minister Maxim Oreshkin, Russia's gross domestic product is due to return to sustainable growth in 2017, and also the period of crisis is ending due to some economic and also other policy changes and some reforms that I'm going to discuss in my next slides, of course. Russia is a federative state with a republican form of government, which means that there is a strict division of powers between the federal government and the government of the individual states. The ruble is the official currency of Russia, having a highly fluctuating value due to its direct dependence on oil prices. And as we say in Russia, the ruble is like a roller coaster, as it experiences plunges and miracle surges in quite a short period of time, and maybe you heard about it a lot. Also, the accession of Russia to the World Trade Organization took place in 2012 and brought a significant improvement of legislation and the formation of a better trade and investment climate, of course, as well as a greater access to world markets. As for corporate tax in Russia, it is 20%, and I must say that of this tax amount, 2% is paid to the government and 18% is paid to regional authorities, as for example opposed to the United States that has the highest top statutory corporate tax rate of 39.1%, and this is the highest of any nation in the G20. Now let's pass on to the political update from the last year, which had quite some milestones. Russia's State Duma elections, which many saw as a precursor to the 2018 presidential elections, were the year's biggest event. And the Russian political scene also experienced quite a few shakeups this year. Of course, new people appeared in the important positions and other top officials were charged with really serious crimes leading to their exit from the political scene. And the parliamentary elections were the year's top political development. A wide-range election campaign included primaries for the first time ever in Russia, as well as the appearance of many new faces. But for example, while the American presidential elections mobilized voters and really pushed them to the polling stations, there was a different situation in Russia. Voters ignored the candidates' efforts and the turnout was low, with no more than 50% of the voters casting their ballots. So that was seen as exceptionally low, and even for Russia, especially after all that was invested in the campaigns, of course. And the same parties are now sitting in the State Duma. As before, the ruling United Russia Party has received more than 54%, up from 49% in 2011. 2016 has also brought some big corruption scandals. The biggest of these included the arrest of Kiev Governor Nikita Belykh and Economic Development Minister Alexei Ulyukayev. As for Belykh, I must say that he was suspected of receiving a large bribe in exchange for privileges to some businessmen in the region he governed. And he was arrested last summer with a suitcase full of money in a luxury Moscow restaurant. Ulyukayev was arrested in a Rosneft office, allegedly receiving a 2 million bribe for a positive review of the Bashneft oil company privatization deal. And he was dismissed from his ministerial post, citing lack of trust. Also, the resetting of relations with Turkey after a failed coup has become a turning point of 2016. And as it is well known, for a long time relations between the Putin and the Erdogan governments were quite good. However, Turkey and Russia relations soared after the downing of the Russian fighter plane over Syria last year, and Russia banned a number of Turkey businesses from the country, including construction and travel businesses, in retaliation for the shoot down of two fighters that had downflown into Turkey's airspace. And only in late June of last year did Erdogan make a decisive step towards mending the strained relations by sending a letter to the Kremlin that was viewed in Moscow as offering an apology for downing the jet. And the letter quoted by Kremlin, it said Turkey was ready for any initiatives to relieve the pain and severity of the damage done. And afterwards, as a result of this restoration action, Putin and Erdogan revived pipeline deal, known also as the Turkish Stream, that would run under the Black Sea to Turkey and then the Greek border, allowing Russian gas to reach Western markets without using Russia's existing export pipelines through Eastern Europe. Let's move on to the Russian economy. And as you may see from the table, all the key figures have gone into a free fall, taking account the figures from 2011 to 2015. And I would like to particularly draw your attention to the GDP indicators of 2014 and 2015. Due to international pressure and the American economic sanctions, these indicators were reduced by half. This same sort of situation happened to the inflation rate, that due to the deep economic recession that doubled over the period of 1 year. And the only positive trend of the recent years that was observed is the stable growth of the population that is deliberate, because this is a part actually of Mr. Putin's maternity capital or fund program that provides federal subsidies for multiple child families by giving out them certificates in approximate value of $8,000 American dollars. And it encourages families, of course, to have more than one child. From this slide, you may see that Russia's main exports have been and still are oil, fuel and gas industries, machinery and equipment industries, metals and chemicals. And as for major markets for Russian businesses, those are Asian partners and China. In particular, and hardly surprising, is that after the political situation of 2014 and 2015, Russia seeks more partnership with Central Asian and Asian allies. However, I must say that some Eastern countries like Netherlands or Germany remain to be also strategically important for Russia, and the same applies to the United States. In general, Mr. Putin's third term as a president has seen a greater emphasis on conservative cultural values, anti-Westernism and great power nationalism. And the standoff with the West is leading to a rollback of Russia's integration into the world economy. And this is likely to further strengthen the state's role in the economy. Tit-for-tat sanctions have encouraged the government to focus on import substitution. And the focus on curbing foreign influence on domestic politics is likely to endure, along with close controls on civil society, the internet and media. And a preference for greater freedom from internationally imposed constraints is nothing new for Russia, but the geopolitical conflict with the West that intensified, of course, after Crimea issue in March 2014, it has resulted in the Russian authorities accelerating their efforts to enhance the country's economic sovereignty. And one of the most important components of Russia's efforts to increase its economic sovereignty is a high-profile import substitution campaign, or as we call it, импортозамещение, that is already well established. And that is it for economic overview. And I would like to talk a little bit about the risk assessment of Russia. As for sovereign risk, despite low oil prices and international sanctions and the contracting economy, the Economist Intelligence Unit does not expect Russia to encounter sovereign financial problems in 2017 and 2018. And public debt remains low, and the government is committed to gradually reducing the budget deficit. This same applies to currency risk, as we expect the currency to appreciate moderately in 2017, as oil prices are forecasted to rise, and also real interest rates will remain positive, although the outlook remains highly uncertain. The Central Bank of Russia may intervene, of course, to hold down the ruble in the unlikely event that oil prices rise rapidly and significantly. And this you may see also the overall country risk rating is estimated as BB. Moving on, I would like to follow up on the Russian judicial system that is quite complex. The Russian civil court system consists of two main branches. The courts of general jurisdiction, which are subordinate to the Supreme Court, and the Constitutional Court, that its main purpose is to ensure that Russian federal decrees are in harmony with the Russian Constitution. It is the uppermost legal body with the headquarters in St. Petersburg, and as for the Supreme Court of the Russian Federation, it is situated in Moscow, and it is the absolute legal form for all tribunals which deal with civil, criminal, and administrative disputes, and acts as a court of cassation. District courts are the heart of the courts of general jurisdiction, and they are the bodies which solve most parts of criminal and civil cases in Russia. Of course, they have more decision power than justices of peace, for example, who are basically local magistrates who rule over very, very small cases. And you may see from this pyramid the scheme of commercial courts, or so-called arbitrage courts, that are also called in Russia as Russian commercial tribunals, generally have control and power of decision over litigations between legal entities. And based on the seriousness of the case, there are four types of arbitration bodies. The Supreme Arbitrage Court was the final court in commercial disputes in Russia, and it supervised the work of lower courts of arbitrage and provided interpretation of the laws and clarity concerning the law's implementation, which is compulsory for lower courts. However, you can see that I crossed out this court because it was replaced by a 30-judge economic collegium that is a part of an expanded Russian Supreme Court now, which became effective on August 8th, 2014, and that has become one of the biggest developments in our modern judicial system. The other arbitrage courts are Federal District Arbitrage Court, Appellate Arbitrage Court, and Arbitrage Courts of Administrative Regions. And here let's move to the legal system in Russia. That is also quite important to discuss. The legal system in Russia is based on civil law that have been codified without any legislative impact, and the main legal framework in relation to debt collection is defined by the Russian Civil Code. This code consists of four parts. The first part deals with general provisions, the second deals with specific types of obligations, third part covers succession law, and fourth part covers intellectual property issues and also private international law issues. Also, we have Civil Procedural Code of the Russian Federation and Federal Law on enforcement proceedings, and also Federal Law on bailiffs. As the Russian economy continues to struggle, issues relating to insolvency remain the priority for both local and foreign creditors. And this table provides recent statistical data, which may be helpful for you in shaping your expectations of companies finding themselves in insolvency scenarios and creditors that contemplate their bankruptcy strategies. Following the economic downturn in the aftermath of the 2008 financial crisis, the number of insolvency applications has been fluctuating. However, immediately after the imposition of Western sanctions in 2014, this number jumped by 20%, resulting in more than 50,000 insolvency applications filed and also approximately 41,000 accepted by Russian courts in 2015. And the majority of insolvency applications were filed by creditors, around 84%, whereas the rest belonged to debtors who, under certain circumstances, are obliged to file for insolvency. And further on, I would like to provide some main guidelines about interest rates in Russia. Interest rate is determined by the key rate of the Bank of Russia, and from September 2016 it was 10%. However, last week it was adjusted down to 9.75% by the Central Bank of Russia. But in general, this percent works in force in the respective periods. And these rules apply if different interest rate is not set by law or contract. Also, accrual of interest on interest, or the so-called compound interest, is prohibited by Russian legislation. And if the payable interest amount is clearly disproportionate to the consequences of breach, the court, in this case, at the request of the debtor, can reduce the percentage specified in the contract, but not less than the amount determined by the key rate. And I remind you again that it's 9.75%. However, I should note that in practice, Russian debtors are not used to paying late payment interest voluntarily, and the payment behavior of Russian debtors is extremely poor, and the law provides no general framework on payment terms. For example, the food sector has a 10 to 45 days payment standard by law, but these are not observed in practice. Also, contractual terms provide a 30 to 60 days basis on average, and in some industries it takes from 60 to 90 days in common. But payment delays are fairly common, although difficult to quantify. And in general, the law does not regulate collection costs incurred during the amicable or pre-suit phase. And when collection is made through court proceedings, the creditor has the right to ask the court to reimburse the cost. And the court will award the costs if the decision is in favor of the creditor. And this is quite a common practice worldwide. As for the ordinary civil proceedings, collection attempts ought to start with a registered demand letter recalling the debtor's obligation to pay the principal together with the late payment interest. And when debts below 300,000 rubles, which amounts to approximately 4,000 euros, are certain and undisputed, then in this case, simplified court proceedings are available. And when all the necessary documents are provided to the court, then the debtor is duly informed and the court tax duty is paid, then these proceedings are fairly efficiently settled. When the debt is disputed, however, it becomes necessary to commence with ordinary civil proceedings, which in practice are complicated to handle. And the claim must be submitted to the court, which will then require the debtor to come to a preliminary hearing. This is a Russian particularity, but failure of the debtor to attend would not, however, entitle the creditor to obtain a default judgment. The courts will normally award remedies in the form of compensatory damages or injunctions, but punitive damages are not available. As for the necessary documents, this is quite a relevant issue, is of course what is the set of documents that should be submitted to court for the start of the legal proceedings. And the following list of documents is needed for litigation. This is of course include contract, invoices or pro forma invoices, shipment notes with signatures of authorized person and stamp of the debtor, demand letter, statement of account, also claim note with the confirmation that it delivered to respondent, payment order, corporate registration statement, and of course power of attorney. Another important issue is time limitations, and you may also question within what time the commercial claims can be submitted to Russian courts. And normally, commercial claims in Russia must be brought to court within 3 years. Although, of course, certain claims may be submitted within 1 year. For example, invalidation of avoidable transaction or sea transportation contracts. And also here, I must say that a failure to bring a claim within the expected time frame does not necessarily bar access to court. Also, as you may know, provisional measures may help to preserve the creditor's interest pending a final judgment. And in this case, upon their request, the courts would typically order interim measures aimed at protecting evidence and or at avoiding irreparable damage. For example, attachment, injunction to do something or to prevent from doing something, protection of rights, and so on. But this process is very formal, and the demanding party must prove the absolute necessity of awarding such measures, which is, of course, quite complicated. But if the demanding party may prove that the debtor was duly informed, the court may order precautionary measures ex parte, which means without all parties being present. And also, arbitral tribunals cannot award such orders, only the state arbitration court. You may also ask how long could legal action take place, and the court process would normally last for 3 months, and another 3 months would be required to enforce the court decision. And if the debt is disputed and the debtor's assets are difficult to locate, this reasonable time frame would not apply. Domestic courts will not need more time to deal with claims involving foreign parties. However, I must say that, of course, certain delays may occur when the documents must be translated or if, for example, foreign witness must be heard. But this is quite an exceptional case. Also, quite a burning question would be how much could it cost to go to a Russian court? And here I must say that the defeated party will normally be required to pay the successful party's court costs, but legal costs will not be fully compensated for, unless perhaps the proceedings have been unduly and abusively delayed. And court fees will apply. This will reach between 3% to 4% of the claim when the debt does not exceed 200,000 rubles, with 4,000 rubles cap. And beyond this point, fees follow a progressive scale. The so-called contingent no-win, no-fee arrangements, whereby the legal costs depend on success, are not allowed. However, of course, the third-party litigation funding is allowed in Russia. Also, Russian law provides no out-of-court debt renegotiation proceedings, and bankruptcy proceedings are normally divided into 2 phases, restructuring phase and winding up stage. Debt restructuring will take place through various stages. The supervision proceedings will first be set up following the publication by the court for a bankruptcy declaration. And the debtor will remain in possession of its right to manage the business, but in this case, a temporary administrator will evaluate the company's financial standing to establish whether or not it is viable. And a moratorium will also be put in place for a maximum of 7 months in order to protect the company from parallel enforcement claims. And if the temporary administrator concludes that the company is viable and may be rescued, in this case, a financial rehabilitation stage may then commence. And upon request of the debtor or the creditors meeting, the debtor may be exempted from paying its debts for a maximum of 2 years. But an administrator is appointed to ensure that the plans on which the parties have agreed are respected. The law, however, provides limitation as to how much of the debt may be written off. And if necessary, a third external management phase may finally be put into place to further assist the debtor company in returning to solvency by appointing. In this situation, an external administrator takes over the company's management under the protection of a moratorium on enforcement claims. The second phase, or liquidation, is the default insolvency procedure. And upon demand of the parties, or if at the end of the supervision process the temporary administrator concludes that the debtor company is not viable and cannot be rescued, in this case a liquidation phase may begin. A liquidator would be appointed to identify the creditors and establish the list of all the admissible claims prior to liquidating the company's assets and also distributing the proceeds to the creditors, according, of course, to their priority needs. And the creditors must file their claims within 1 month after the publication of the bankruptcy declaration by the court. As in many legal systems, priority rules normally apply in Russian courts while distributing the proceeds to the creditors. The various legal costs, as well as the new loans contracted during the restructuration phase, are given absolute priority over the claims, for example, employees' claims or unsecured creditors' claims, and etc. And another relevant question is, for how long could insolvency proceedings normally take place? And on average, it takes place from 2 to 2.5 years. However, as I already have mentioned, the exact time frame depends on the particular region and court. And normally Russian courts are quite busy, especially in big cities like Moscow, St. Petersburg, or Kaliningrad. So in some cases, it may take up to even 3 to 4, 5 years. And again, it is very important to have full set of documents while submitting a bankruptcy claim, as the correct package of documents will save your time and money, of course. And these documents are quite similar to those previously discussed during the ordinary civil proceedings stage, and are the following. You should provide, of course, contract invoices, and again pro forma invoices, shipment documents showing the signature of the authorized person and the debtor's corporate seal. Demand letter, of course, statement of the balance due, certified notification of the debt due, debtor's corporate registration statement, and power of attorney. And of course, if you have any, then also you should provide court title. That was actually it from my part, and that was quite a brief overview of Russian business and collection environment. But before we conclude our webinar, I would like to share with you some relevant links with public source of information about your Russian counterpart. For example, where can you find information about a company? Very basic information. And here we have the National Register of Legal Entities, or so-called YGRUL, that keeps an online database of registered companies, and you may see the link of this website. Another very important and maybe useful link for you can be the credit checks. All the information regarding financial statements and about your business counterpart can be found via Russian Federal Tax Service Russian Federal Tax Service. It provides a public database which offers tax-related information and also other data related to the status and activities of company. And this third link that I indicated here is the judgment search. So if you want to know if your business counterpart has already a judgment, or if your counterpart is involved in legal proceedings, you may follow the third link. But I must say here that unfortunately all links are available only in Russian. So unfortunately, maybe for some of you it can be a problem to access it. But that was it from my part. And Stephen, are you still here?
I am here, Ekaterina. Thank you very much for a very informative overview of Russia's legal environment. And we have quite a few questions on the line. And let me start with the first one. What are the easiest and the most difficult sectors in Russia for lawyers to make successful collections?
As I previously indicated, we do have some economical areas, like, for example, or export or import areas like oil and gas industries, and those industries are quite complicated for lawyers to deal with. But also the state, claims where states are involved in the proceedings are also quite complicated to deal with, because you know that in Russia we have quite a complicated political system, and some companies have really big interference or involvement of states. So if lawyer gets a case where the state company is involved, then it's indeed quite a complicated case.
Very good. Next question is, can you go back to your slide 13 regarding Russia's level of company insolvencies?
Yes, sure.
And are the bankruptcy or insolvency levels in 2016 comparing to 2015? What's the trend? Are they reducing? Are they staying the same? Are they increasing? What's your personal opinion?
Yeah, I must say that unfortunately in this slide it is not indicated, but I'm pretty sure, and I also read some statistics, and with all the sanctions and with all the economic situations, the rate of the bankruptcy files in 2016 again went up. And my personal estimation is that it also went up to approximately 20%. So, unfortunately, this tendency is quite common in Russia, that companies are getting more and more bankrupt. But as I also previously indicated in my slides, especially in the credit assessment risk slide, that now the economic situation is getting indeed way better. So we expect in 2017 the decrease of the bankruptcy cases filed in Russian courts.
Okay, thank you. Our next question, sometimes in the U.S., if many creditors are owed a lot of money by one debtor, they are able to band together in a suit and force that debtor into a Chapter 11 bankruptcy with an administrator to handle that debtor's operation. How about in Russia?
Well, I must say that the same strategy also works in Russia. So this is also quite possible, and I would say that it's even way similar to American practice.
Very good, thank you. Going back to your slide 11.
Yes.
If a creditor needs to sue a debtor, the first stage court is where the suit is commenced. Do many suits get appealed?
Yeah, I must say that appellation is quite a common practice in Russia as well, and it happens for different reasons. Sometimes the debtors are struggling for their rights until the very last moment, so the appellate claims are quite common in Russia.
Okay, the next question. In the U.S., there is the National Association of Credit Management, which has thousands of credit manager members. Is there a similar organization in Russia?
We have such an organization that is called Institution of Credit Management in Russia. And I must say that this institution is quite a new institution within Russia. So it is not probably as well developed as in the United States, but it is very interesting to see how they're developing. So yes, we do have this kind of institution.
Very good. Thank you. You mentioned that even if the debtor does not attend the court, this does not automatically mean there will be a default judgment. What would cause a default judgment?
Well, it depends on the particular details of the case, but as a general practice, a default judgment can be, it's really a case-by-case nature. So, of course, if the debtor does not appear, it will not cause to this. But, for example, well, maybe if the documents were not provided incorrect, or for example, if there are some missing documents, or if there are, even the worst case, if there are some fake documents, then there will be a default judgment.
Okay, very good. We have a claim that is 5 years old. The debtor is in Moscow. He has from time to time responded to our emails regarding payment, but nothing so far. Is it too late to sue?
Well, as I already stated in the slide, one of the slides, let me find this slide. We do have the time frame for providing your claims. So I found this slide, and normally all the cases should be brought to the court within 3 years. So if this is quite an old claim, then unfortunately in this case you cannot do anything. However, I should say that if your debtor replied to your messages and in some emails admitted the claim, the debt, then there is a possibility that you may still bring your claim to court. For example, if he responds to your email, let's say 1 year ago or 2 years ago, stating that, he admits the claim, but he does not have money for some reason, then you may still submit the claim. And I think there is still some, indeed, possibility that the court will consider this kind of claim.
Very good, thank you. The next question is, would you recommend that knowing the debtor's liquid assets, like money in their bank account, be confirmed in advance before going down the road of litigation?
Can you please, Steve, repeat the question, because there were some problems with connection?
Sure. Would you recommend that knowing the debtor's liquid assets, cash assets, like money in their bank account, be confirmed in advance before going down the road of litigation, before suing them? And I think the question is, the meaning inside the question is, in view of the costs, it doesn't seem to make sense to sue if you don't know if you can seize the debtor's assets.
Yeah, of course. I got the question, and now I clearly understand it. The thing is that all the time when, for example, I deal with cases, I recommend to do a check of the company, and this check includes, of course, knowing how much cash in cash the debtor has. So there is no point to seize bank account of the debtor, of course, if there is no money. And I must say also that, unfortunately, some state registers that provide this kind of information, they do have this information relevant, but it does not necessarily mean that in fact, or like in a real life, the debtor has the same result as it was shown from the state registers. So, for example, on paper, unofficially, or the other way around, officially, it may be stated that the debtor has lots of assets and cash, but in reality, the debtors cannot have even any money to meet the obligations.
Very good, thank you. In the case of fraud, can a creditor pierce the corporate veil and go after the president or owner of the company to satisfy the obligation?
Yes, we do have this practice of, let's say, unveiling the corporate veil, but also this is quite a, let's say, young phenomenon in Russia. So as far as I know, this practice is now more and more used by Russian courts, or not even by courts, but by parties. So yeah, this can be a case in Russian courts and Russian legal proceedings.
Okay. Is there a hierarchy of creditors? For example, are there secured and unsecured creditors in a bankruptcy? And this is a long question. The next part is, how can or should a creditor become a secured creditor at the time they commence business with a Russian customer?
Well, we do have, two lines, of course, of secured and unsecured creditors. And I must say that secured creditors are basically those who strictly prescribed it in their contracts with the debtor. And also secured creditors have the privileged right to file for during the bankruptcy proceedings. So there is, of course, my advice for you to prescribe in your contracts and also to be the first one during the bankruptcy proceedings, because indeed the secured creditors do get way more benefits during the bankruptcy stage.
Okay, that's very interesting. The next one is, does obtaining a judgment in your favor, in the creditor's favor, make you a secured creditor in the event that your customer does go bankrupt?
Yes, it does, and also depends on the circumstances of the case, but as a general practice, it does.
Okay. The next question is, in the U.S., we have what is called UCC filings against the product and merchandise that is sold. It's like a lien on the product, so that when the product is shipped to the customer, it has to remain separate from the rest of the inventory at the debtor's location until it is used. In the event of bankruptcy, that the creditor has the right to reclaim that inventory because of this UCC filing. Is there such a mechanism in Russia?
Steve, I'm pretty aware of this mechanism in American law, and I find it also very useful for your manufacturers, let's say. But unfortunately, in Russian law, we do not have this kind of mechanism to protect the subcontractors and the suppliers' rights.
Okay. Are companies required to submit audited financial statements to obtain bank loans?
Yes, they are obliged to provide this kind of information, and if I'm not mistaken, this information should be provided once per 3 years. So it's really a full investigation of not investigation, but the full company profile and the full information about the company, statements and everything. But also companies do need to provide the shortened information once per year as well. So we do have this kind of audit of companies.
Very good, thank you. The next question, are there banking and overseas remittance restrictions within Russia? In other words, can creditors freely send out overseas payments?
Steve, I also find this question quite relevant, and I will explain why. Because actually recently, last week, as if I'm not mistaken also, there was a new law adopted that introduced restrictions on cross-border transfers of funds from Russia, but only in the event that a foreign state introduces bans on payment systems and the operators of which, for example, are registered with the Central Bank of Russia. So, for example, if a foreign state has a ban on receiving money transfers from Russia, or let's say a ban on attracting payment infrastructure service providers that are located in Russia, or a ban on participation in payment systems, then Russia takes also these kind of tit-for-tat measures. And actually today even I saw the update that this law was signed by Mr. Putin, and so from now on, if a foreign state has introduced, for example, bans against Russian payment system, then the cross-border transfer of money from Russia to this state can be processed only, for example, with the help of operator or service provider that is under the control of Russian legal entities. So these rules will be applied only for cross-border transfers, but I know that these rules are applied for cross-border transfers that in case where bank account had not been opened, so only in this case.
Very good, thank you. This next question, I'm going to try to rephrase it because it's a long question. In my country, I can seize a bank account without a judgment, but I first need to put up a bond if I'm going to try to seize the account. After I seize or I freeze the account, I then go to court. Is there something similar to this in Russia?
You know, in Russia, it works a little bit different because a seizure of a bank account can be carried out only by the order of court or by the court judgment. And, for example, also not necessarily by the general court, but also the arbitration court. And also in exceptional cases by the decision of the preliminary investigation bodies, if also, again, there is an order. And it is normally executed by the bailiff. In this case, the bailiff acts only after having the court judgment.
Okay. Our next question is it necessary for the creditor to be a witness in court on a case that is being sued but also being disputed? Can the creditor designate someone to represent him?
You know, actually, according to Russian law, witness is an independent participant of legal proceedings. So he should be impartial and unbiased participant in these proceedings. So I think it is not really correct to say that a creditor can be a witness in legal proceedings. Of course, a creditor has a right to participate or not to participate in legal proceedings or in dispute. But I must also say that in commercial disputes, a witness is rather an exception than a common practice.
Okay, thank you. Instead of a suit, is there a formal arbitration or dispute resolution system in Russia? For example, in my country, in Brazil, a formal arbitration system has been very well established and is a very common method because our suit process is so long. How about in Russia?
Well, of course, we also have arbitration system in Russia, and I must say here that I told a couple of times during my presentation that we have arbitrage courts, but these courts have nothing to do with arbitration, the private arbitration institutions. And as for the arbitration in its common use, we do have this system in Russia, and it is regulated by the law, which is also called Law on International Commercial Arbitration. And this law actually also is generally based on the provisions of the Unilateral Model Law on International Commercial Arbitration. And also, of course, here maybe the relevant addition will be that the Russian Federation is also a part to the New York Convention of 1958 on the recognition and enforcement of foreign arbitral awards. So also maybe what is important to know that Russia is a party to the European Convention on Foreign Trade Arbitration. So we do have a well-settled and well-developed arbitration system besides the system of state courts.
Very good, thank you. Is payment by credit card a common method of payment for consumer and or commercial transactions?
Yes, I must say that nowadays more and more people in consumer transactions are using credit cards, and this is quite a convenient way of paying. And this is, you know, also for a reason of bringing some proofs to courts. It's also very useful to pay because the transaction via credit card gives an access to online cabinet, and then if somebody brings a claim against you, and then you may use this proof in court as a proof of your, as an evidence, you know. And also, of course, people are also paying in cash, but then the proof of payment in cash will be a receipt. That is not the case sometimes, because for some reason, some organizations, some legal entities and businesses do not provide receipts for different reasons. But yeah, the payment in credit cards is quite common.
Very good, thank you. The next question, what kind of items should be absolutely included in the initial credit application or contract that would make the legal process much easier? For example, are personal guarantees included in a credit application and signed off by the company owner or president acceptable business practice? There's also another part. Also, should the corporate registration statement be requested in advance?
You know, Steve, yes, those personal guarantees are quite a common practice, and I also deal a lot with personal guarantees in the contracts. And maybe I will give a very basic tip. As for each particular agreement, certain rules are applicable, so it really depends on different agreements. But in general, I highly recommend to have signatures and corporate seals on every page of the contract, because yeah, in the end of the contract, I also recommend to make sure that you have requisites of the parties, because in Russia, the common practice is that businesses, while contracting, they sign and stamp, or they put the corporate seal on the last page of the contract. But sometimes for more guarantees, let's say, or for securing themselves, they even put these signatures and corporate seals on every single page, so that there will be no fraud or other kind of illegal methods, you know.
Yekaterina, there are several questions in the queue, and there's a question down in the queue that's sort of related to this. And that question is, in your contract, can you state that you will automatically become a secured creditor?
Yes, you may, yes. And actually, this is not something that you, necessarily include in your contract. But we have this rare practice, and courts also turn to this.
Okay, and we're assuming also that all these contracts and applications should be in Russian as well as in English.
Yeah, of course, double languages are very practically used practice, but what I also recommend is, in case you have two languages contract, give a preference and indicate it clearly in the contract that you give a preference to an English version of your contract. And I think it is quite understandable why.
And of course, you recommend that all these documents, especially for companies doing business with Russia for the first time, all be examined and confirmed by an attorney.
Yes, of course. Yeah, the power of attorney is a must when you deal with contracts and when you deal with businesses and litigations.
We have so many questions in the queue, and I think we're just going to have time for one more question. As our company sells special solar-based energy equipment that is installed into a structure, is it possible to file a mechanics lien against the property where the equipment that is installed becomes a permanent part of the structure? Is it possible to initiate a foreclosure proceeding on a property where you have a valid lien?
Well, as I already also stated, that unfortunately we do not have this kind of mechanism like mechanics lien. So, and we do not even have similar proceedings. So this is really good advantage, I must say, of American practice.
Well, although we still have several questions in the queue, this is all the time we have today for the questions. And to all the attendees, Yekaterina will address the remaining questions to you separately by email. Before we end today's session, a couple of quick items. Please feel free to join the European Legal, Credit, and Debt Collection Forum discussion group on LinkedIn, which now has about 1,200 members. We have many credit and collection risk professionals, and you will find our discussions and comments to be quite informative and valuable. Again, the name of the group is the European Legal, Credit, and Debt Collection Forum. I would also like to mention that the Bierens website is bierensgroup.com. group.com. That's Bierens group.com. As part of our webinar series, about once a quarter, we'll be profiling the credit and collection situation in another European country or region that we believe will add value to your international sales and global credit risk management needs. You'll be hearing from us again in a few weeks about our next webinar on June 20th, titled The Credit and Collection Environments of Central and Eastern Europe. Finally, you'll be receiving a thank you note from us that will contain all of the contact information of our presenter, Ms. Titova, for your reference. By all means, please feel free to contact her regarding any questions, comments, or needs that you may have. Yekaterina, thanks so much again. And to everyone, thanks so much for joining us, and I'll now be ending the session. Thank you very much.
Thank you.